So, what's important to start with is to make sure that you understand this objective test. That in order to identify whether or not, in the absence of some sort of express provisions, that the parties have manifested or demonstrated an intention to enter into legal relations, courts will take into account a range of different things. Uh, this 1970s case of Merritt is really instructive on this question, and it demonstrates, for me at least, the start of a shift from the traditional. If you're in a family relationship, there's no intention, to the modern approach that we have now, where it doesn't take a great deal to demonstrate intention, and it's quite possible that parties who are in a domestic, social, or family relationship can have intention. So, in that case, Mr. and Mrs. Merritt were married for some time, and then he left her for another woman, as happens from time to time. And they were not on good terms, and they entered into a relationship, into an agreement in relation to the ownership of the house. And at first instance, it was found, because they had been married, that any promises that he made to her in relation to the house couldn't be seen as binding. But Justice Denning, I should say, Lord Denning, took into account a range of different circumstances and said that intention should be determined by whether the reasonable person, so an objective test, regards the agreement as intended to be binding, not by what they actually intended, not by the fact that he just said that to get her off his back. So the Court of Appeal held in that case that the nature of the dealings between the parties, and the fact that Mr. and Mrs. Merritt were separated and not on good terms at the time that they signed their contract, allowed the court to assume that their agreement was far more than just a domestic relationship or arrangement. The next case, Australian case here, that's really instructive is Air Great Lakes and Easter Holdings. This case is not in your textbook, but it's available to you through the links in the course website. So in that case, that's authority for the proposition that the court can take into account the surrounding circumstances, including the actions and statements of the parties, as well as the terms of the document. So here, at one level, this is kind of an exception to the parole evidence rule, which is something that we'll discuss a little bit later on. So in this case, so this goes back to December 1981, where Air Great Lakes and Mr. Lynch, Mr. Greenway, and Mr. Baker entered into an agreement with an organisation called Easter Holdings, under which Easter Holdings agreed to buy from Air Great Lakes the goodwill of the airline business that it operated, and that Easter Holdings would purchase the plane for $140,000. And a document detailing the terms of the agreement was signed by all the parties in December, actually on New Year's Eve 1981, after a series of conversations. And later, when asked to be held to account under that contract, Easter Holdings said that the signed document was just a non-binding draft. It wasn't meant to be binding, and what it signified is that a binding agreement would be drawn up later. This is something that we'll look at again over the course of this topic. Justice Marnie said the existence of a contract is a consequence of what the parties have said and done. So this is an objective approach to ascertaining what the intention of the parties are. So the intention to contract in a subjective sense is relevant to, but not determinative of, the existence of a binding contract. So if A says, I promise to sell Blackacre to B for $100, and B says, I promise to buy Blackacre from A for that price, a binding contract will be held to exist even though neither A or B subjectively intended that consequence. If they're both joking, they're joking. But if A knew that B was merely play acting, then B's subjective intention would be effective to prevent the contract arising, but only because A knew of that subjective intention. So the words of Lord Denning reproduced here. The court does not try to discover the intention by looking at the minds of the parties. It looks at the situation in which they were placed and asks itself, would a reasonable person having regard to the would a reasonable person regard the agreement as intended to be binding? This all comes to a head in one of my favourite cases, actually, Shahid and the Australian College of Dermatologists. So you'll find more information about that case at paragraph 507 of your textbook. And basically, in that case, is authority for the proposition that the courts will look at whether payment has been made and accepted, what kind of a relationship the parties had, and if there's an arm's length relationship, there is a presumption of intention, and they will look at the terms of the documentation. Shahid's a really interesting case, actually, and it's kind of bizarre that it went to appeal at some level. Again, probably putting my politics ahead of anything else. I see this very much as a case about discrimination, actually, as opposed to a contract case. But it illustrates the point really well. So essentially what happened is the Royal College of Dermatologists would run training programs, and until you've actually gone through their hoops, you couldn't be a registered dermatologist. And Dr. Shahid basically applied to do the training program and was rejected a number of times. They had an appeals process. She then went through the process of paying some money to have her appeal reviewed, and they still rejected her. So she then appealed to the courts. And at first instance, the college basically argued that there were some fit issues, some things that they hadn't put into their rules that she didn't meet. And the judge at first instance accepted those arguments. But on appeal, the full court, I think it was the full court, yes it was, the full court held that the trial judge was wrong to take into account what he called their, uncommunicated intentions. And they looked at all of the evidence, and they looked at the factors, which gives us this great test that we have now. They looked at the fact that she paid money, that there was a set of rules in the documentation that she had complied with. And they also, well, she was clearly not part of their club. They didn't want her to be part of their club. So their relationship was absolutely arm's length. The section in the textbook is really instructive. So from Justice Jessup's judgment, and you'll find it on page 117, and he talks through there in the quote there the link between intention and consideration. So I absolutely recommend that you have a good look and think about the way that case worked.